So again, very good morning, friends. So let us cover the rest of the cases. And I think we can stop at 27 because 27 cases are there. So we'll stop at 27 cases only today. This is the case of Ghanshyam Mishra and Sons Private Limited through authorized signatory versus Edelweiss Asset Reconstruction Company. So in this case, the facts was that this Ghanshyam Mishra and Sons Private Limited and Edelweiss Asset Reconstruction Companies, they both were resolution applicants to OMMPL. Now, this multiple special leave petitions were filed before the Supreme Court arising from the case Electro Steel Steels Limited versus State of Jharkhand and others. Then Messrs. Monet Ispat uh, versus State of Odisha and another. Then Ultratech Nathdwara Cement versus State of UP. And Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction. The effects of these cases are pretty similar as in communication issued to the operational creditors, mainly tax authorities, that post approval of the resolution plan, all the pending recovery actions against the corporate debtor shall stand withdrawn. So the matter here is that suppose there are some dues which are, there is some money which is due to the, say, GST department, but a resolution plan has been passed, it has been approved. Now, once the resolution plan has been passed, whether all these liabilities of government department, whether they will stand extinguished. So this was the issue. And similar was the issue in some of these cases like Ultratech, Nathdwara Cement, etc. and other. Because government authorities, government officials think that, okay, even if resolution plan has been passed, they even then they keep on raising the demands. Sometimes they raise the demand against the replaced resolution applicant itself. So the issue here was whether any creditor, including the central government, state government, or local authority, is bound by the resolution plan. Whether this is binding on the government authorities also once it is approved by an adjudicating authority. So the answer is yes. Another question was whether the amendment to Section 31 by Section 7 of Act 26 of 2019 is clarificatory, declaratory, or substantive in nature. So it says it is clarificatory and it is applicable with retrospective effect. And another issue was whether after approval of resolution plan by the adjudicating authority, a creditor, including the government, state government or any local authority, is entitled to initiate any proceedings for recovery of any of the dues from the corporate debtor which are not a part of the resolution plan approved by the adjudicating authority. It was held no, that once a resolution plan has been approved, then even the central government, state government or local authority is not empowered to initiate any proceedings for recovery of the dues. Whatever they got, they got. So this was the issue. Next is Asset Reconstruction Company India versus Bishal, Jaiswal and another. So in this case, the issue was whether Section 18 of the Limitation Act, which extends the period of limitation depending upon acknowledgement of debt made in writing and signed by the corporate debtor, is also applicable under Section 238A, given the expression as far as may be governing the applicability of the Limitation Act to the IBC. It was held yes, that once there is an acknowledgement of a liability, then it gives a fresh lease of life. And Section 18 of the Limitation Act is applicable. Another issue was whether an entry made in a balance sheet of a corporate debtor would amount to acknowledgement of liability under Section 18 of the Limitation Act. Suppose there is an entry in the balance sheet. So whether it amounts to acknowledgement of a debt, so it was held yes. Asset Reconstruction Company Limited. Let us see some further details. So in this case, default took place in the year 2015 itself, but the application was filed under Section 7 before NCLT for a default amounting to 59 2.97 crores from the corporate debtor by filing a supplementary affidavit before the NCLT, specifically mentioning the date of default and annexing copies of the balance sheet of the corporate debtor, which according to the appellant acknowledged periodically the debt that was due on 8th of November 2019, which was admitted by NCLT as well. So here the issue was, once a fact is being mentioned in the balance sheet on a continual basis, so whether it amounts to acknowledgement, and this fact was this application was admitted by NCLT also. However, the corporate debtor appealed saying it was time barred because the default took place in the year 2015 itself, but it was shown as due in the balance sheet as late as 2019. So entries in the balance sheet would not amount to acknowledgement of debt for the purpose of extending limitation under Section 18 of the Limitation Act. This was the plea taken by the appellant. So the issue was whether Section 18, which extends the period of limitation, is applicable under Section 238A, and whether any entry made in the balance sheet would amount to acknowledgement. So what were the arguments? Arguments was that a balance sheet has to be filed under compulsion of law, but it does not mean that an acknowledgement of debt has also to be made under compulsion of law. So analysis is on the facts of the case. The NCLT, by its judgment dated 19th February, recorded that the default in this case had been admitted by the corporate debtor, and that the signed balance sheet of the corporate debtor for the year 2016-17 was not disputed by the corporate debtor. So as a result, NCLT admitted the application and said it is not barred by limitation and therefore admitted the same. So this appeal is therefore allowed and the matter is remanded to the NCLAT to be decided in accordance with the law laid down in the judgment, because NCLAT had reversed the judgment, but Supreme Court did not find any fault in the NCLT judgment and it remanded the case back to NCLAT. So it says that acknowledgement of debt is extension of the limitation period, and entries in a balance sheet amount to acknowledgement of debt for the purpose of extending the limitation period under Section 18 of the code. Next case was regarding this Sheshnath Singh and another versus Vaidhyabhati Shirofuli Cooperative Bank Limited. So in this case, account was declared NPA on 31st March 2013. Just a minute. So in this case, account was declared NPA on 31st March 2013, and the creditor initiated proceedings under SARFAESI Act. So this proceeding was earlier going on under SARFAESI Act in 2014, which was stayed on 24th April 2017. And on 27th of August 2018, application was filed by the bank under Section 7. On 25th April 2019, adjudicating authority admitted the application, but this admission was challenged in NCLT, being time barred because it was said that this application is being filed 5 years from the date the account became NPA. So the question here was whether the delay beyond 3 years in filing an application under Section 7 of the IBC can be condoned. In the absence of an application for condonation of delay made by the applicant under Section 5 of the Limitation Act, because in this case the applicant did not file an application for condonation of delay. So whether still this delay can be condoned. So the finding here was that in the first question on Section 5, the judgment was that there is no statutory requirement that condonation of delay has to be applied. Condonation of delay has to be applied or it has to be sought by way of a formal application. So even in cases where there is no formal application or there is no formal request, still the delay could be condoned. According to the court, the absence of an application does not prevent a court from condoning delay as long as there are materials on record disclosing sufficient reasons. So this was the first point. So whether application under Section 5 is essential, Supreme Court said no. If there are reasons, then delay may be condoned despite the fact that no formal application has been lodged. Next was whether Section 14 of the Limitation Act applies to applications under Section 7 of the IBC. If so, is that exclusion of time under Section 14 available only after the proceedings before the wrong forum terminate? So this question, regarding this question on Section 14, the court opined that the provisions can be invoked in the present case, that the time spent by the financial creditor in relation to previously instituted SURFACE proceedings could be excluded such that the application under IBC was within time. Because in this case, proceedings were ongoing under SURFACE Act. So then the applicant said that, okay, my this much time has been lost in proceedings under SURFACE Act. Now I have come before this IBC. So this time period which was lost in SURFACE proceedings should be excluded, and the court acceded to that request, and the court found that that time spent by the financial creditor in relation to the previously instituted SURFACE proceedings could be excluded. Okay. And another point was that it is unnecessary to wait the termination of the proceedings before the wrong forum to obtain the benefit under Section 14 of Limitation Act. थोड़ा ज्यादा ही बड़ा हो गया ये. Next case is Pratap Technocrats Private Limited and others versus Monitoring Committee of Reliance Infratel Limited. So in this case, the appellants, they are the operational creditors, the Pratap Technocrats Private Limited, and the issue was of valuation of preference shares held by subsidiary and their distribution is challenged. Further, certain indirect financial creditors have to be excluded from COC. So the issue was, does the exclusion of some indirect financial creditors from the COC bear any consequence on the credibility of the resolution plan? So the Supreme Court held no, because the resolution plan is passed with 100% vote. And second point was, what is the extent of jurisdiction of the adjudicating and appellate authority while dealing with the approval of a resolution plan? So Supreme Court said that adjudicating authority is confined to the discipline and boundary of the statute and is only required to ascertain if a resolution plan meets the criteria under IBC. Another principle which was decided was that the principle of equitable treatment applies as between creditors belonging to the same class, which is emphasized by explanation 1 to section 30, subsection 2, subsection B. So in this case, CIRP of Reliance Infratel was initiated and a resolution plan was submitted by Reliance Digital Platform and Project Services Limited, resolution applicant, which was approved by 100% majority of COC. The appellant, he was an OC, this Pratap Technocrats, he challenged the decision of the NCLT approving the resolution plan before NCLT on the following grounds. First is that the claims of the appellants had not received a fair and equitable treatment. Another was there were material irregularities in the accumulation and disbursal of funds that constituted the corpus of the corporate debtor. RP did not provide any details regarding disposal of funds towards their claims, and the appellants were made to suffer a reduction of 90% of their total claims because he was an OC, while substantial claims of nearly rupees 20 crores have been rejected. So one of the financial creditors, Doha Bank, challenged the admission of claims, stating that 21 indirect creditors were excluded in constitution of COC. However, NCLAT rejected the appeal and then the matter went on to Supreme Court. So the issue here was whether exclusion of some indirect financial creditors from the committee of creditors has any consequence on the credibility of the resolution plan. Though it said no. And what is the extent of jurisdiction? So it said that the adjudicating authority is confined to the discipline and boundary of the statute and is only required to ascertain if the resolution plan meets the required criteria which has been set under the IBC. So one of the issues was the realizable value for the corporate debtor on account of any proceeds realized from the preference shares held by its subsidiary, whether it is included in the determination of the liquidation value of the corporate debtor. So it has been clarified that even if the liquidation value of the realizable value of the preference shares were to be considered in isolation for distribution among all the operational creditors in terms of the priority contained in section 53(1), the liquidation value due to the appellants would still remain at nil. उन्होंने कहा भाई ऐसा है, ये जो ऑपरेशनल क्रेडिटर है इनको तो फिर भी नील ही मिलना था, ठीक है, तो इनका तो कोई फर्क पड़ा नहीं इनको इसमें. Or consequences of exclusion of certain financial creditors. So in this case, the resolution plan has been duly approved by requisite majority 100%. So whether or not some of the financial creditors were required to be excluded from the COC is of no consequence once the plan is approved by 100% voting share of the COC. So this was the brief case. Next case is Ebix Singapore Private Limited versus Committee of Creditors of EduComp Solutions. So the resolution plan was passed with 74.16% majority and further delayed vote in favor by 1.195%, resulting in more than 75%. So issue of late delay to be dealt with application before NCLT. So the issue here was whether NCLT has power to allow withdrawal of because resolution plan got delayed. So in this case, the resolution applicant was no more interested, and the issue here was whether the NCLT has power to allow withdrawal of resolution plan submitted for its approval after approval of COC, and then COC rejected the withdrawal application. So it said that no, this power does not lie with NCLT. So NCLT allowed the third withdrawal application filed by Ebix under section 60 subsection 5 of the code to withdraw its resolution plan submitted for EduCom. So while reversing that order, NCLT held that the application to withdraw from the resolution plan could not have been allowed since it was barred by res judicata, and NCLT does not have jurisdiction to permit such a withdrawal. So once a resolution plan has been approved, it cannot be withdrawn by the resolution applicant. The correctness of the view of the NCLT comes up for determination in the present appeal. So NCLT here held that once the resolution plan was approved by the COC, the NCLT did not have jurisdiction to permit its withdrawal. The adjudicating authority could not enter upon the wisdom of the decision of the COC to approve the resolution plan. The resolution applicant had accepted the conditions of the resolution plan and no change could be permitted. Orders have already been reserved in the approved application. No special investigation audit has been conducted. Section 32A of the IBC grants full immunity to the resolution applicant from any offenses committed before the commencement of the CIRP. And Ebix had participated in the process from August 2018 to January 2019 when orders had been reserved on the approved application. Hence, it could not claim any right based on delay. So the issue here was, can a resolution plan be withdrawn or modified by the resolution applicant while it is pending for approval by the NCLT? We know in some cases there are inordinate delays in by NCLT. By a resolution plan has been approved, but suppose it keeps lying with NCLT for 2-3 years, then whether the resolution applicant has the power to withdraw the resolution plan submitted. So in this case, due to COVID pandemic, there had been significant impact on the businesses of the corporate debtor and upon successful resolution applicants whose plans may not have been sanctioned by the adjudicating authority in time. So if the legislature in its wisdom were to recognize the concept of withdrawals or modifications to a resolution plan after it has been submitted to the adjudicating authority, it must specifically provide for a either under the IBC and or the regulations. But there is no such either under the IBC or the regulations. So once submitted to the adjudicating authority, it cannot be withdrawn. The existing insolvency framework in India provides no scope for effecting further modifications or withdrawal of COC approved resolution plans at the behest of the successful resolution applicant once the plan has been submitted to the adjudicating authority. A resolution applicant, after obtaining the financial information of the corporate debtor through the information utilities and pursuing the information memorandum, is assumed to have analyzed the risks in the business of the corporate debtor and submitted a considered proposal. A submitted resolution plan is binding and irrevocable as between the COC and the successful resolution applicant in terms of the provisions of the IBC and the CIRP regulations. But Supreme Court also noted that NCLT and NCLT should be sensitive for delay. There should not be any inordinate delay. According to the 32nd report of the Ministry of Company Affairs Standing Committee on the implementation of IBC, pitfalls and solutions, a delay in the resolution plan with more than 71% cases pending for more than 180 days is in deviation of the original objective, because everybody has to act expeditiously, and timeline for CIRP that was envisaged by the IBC. The delays were attributable to the NCLT taking considerable time in admitting CIRPs, then late and unsolicited bids by resolution applicants after the original bidder becomes public upon passage of the deadline for submission of the plan, because some bidders they enter at the last minute once things are revealed, and multiplicity of litigation and the appellant processes to the NCLT and the Supreme Court. Such inordinate delays cause commercial uncertainty, degradation in the value of the corporate debtor, and makes the insolvency process inefficient and expensive. So Supreme Court urged that NCLT and NCLT need to be sensitive to the effect of such delays on the insolvency resolution process, and they should take cognizance of adjournments that hamper the efficiency of the judicial process. So an endeavor should be there to strictly adhere to the timelines which are stipulated under the IBC, because it is a time bound mechanism, and clear pending resolution plans forthwith. Judicial delays was one of the major reasons for the failure of the insolvency regime that was in effect prior to the IBC. It cannot be let the present insolvency regime meet the same fate. So this was some of the findings of the 32nd report of the MCA Standing Committee on implementation of the IBC pitfalls and solutions. Next case is Lalit Kumar Jain versus Union of India. So in this case, the notification dated 15th of November related to personal guarantors was challenged. Because as we know, the regulations regarding personal guarantors have been notified. But this notification, which has been issued by central government, it operationalizes the code so far as relates to personal guarantors to the corporate debtor, because section 79 pertains to definitional section for the purpose of insolvency resolution and bankruptcy for individuals before the adjudicating authority, and 94 to 187 outline the entire structure regarding initiation of resolution process for individuals before the adjudicating authority. So the issue involved was, what is the validity of the notification dated 15th of November 2019, which has been issued by the central government regarding personal guarantors, and validity of the IBC application to adjudicating authority rules 2019, validity of the regulations challenged by the IBBI on 20th of November, and what is the liability of personal guarantors to the corporate debtor if resolution plan is approved in their case. Because what we have studied is that even if the resolution plan is approved, still the personal guarantors are not absolved of their liability to the extent they have guaranteed. So the analysis and decision was that the approval of resolution plan relating to a corporate debtor does not operate so as to discharge the liability of the personal guarantors to the corporate debtor, because the resolution applicant, while submitting a resolution plan, takes into account the personal guarantees offered by the personal guarantor, and the release or discharge of a principal borrower from the debt owed by it to its creditor by an involuntary process, that is by operation of law, or due to liquidation or insolvency proceedings, does not absolve the security oblique guarantor of his or her liability, which arises out of an independent contract. Because the liability of the guarantor is coextensive with that of the borrower, so guarantor does not stand absolved of its liability because it is an independent contract. And personal guarantors are different from corporate debtors. So personal guarantors can be classified distinctively and separately from other individuals. Okay? And the impugned notification is fully legal and it is valid. It is not an instance of legislative exercise or amounting to impermissible and selective application of provisions of the code. There is no compulsion in the code that should at the same time be made applicable to all individuals, including personal guarantors, or not at all. Because as we know, the various provisions of IBC have been enforced at different dates, and some of the provisions relating to IBC are yet to be enforced. Some regulations are yet to come. So this notification regarding personal guarantors is fully valid. Okay. I think we can stop here for the day because it's already 1 o'clock.
Yes,
And
sir. Yes, sir.
next time, then we can discuss the
Thank you so
High
much.
Court. So thank you very much
Thank you,
for
sir.
being
Thank
with
you,
us.
sir.
Haji. Okay.
Thank you.
Okay.